So Paul, how did you get into cost law?
Well, Mike, to be honest, I drifted into cost law fairly early in my career, but I found it's an area that's become much more significant for lawyers in recent years. I found, really that costing is front and centre for almost any practitioner.
You come from a construction law background?
Yes, originally a building construction litigation lawyer, really on the defence side. So we've done a lot of work for plaintiff firms and defendant firms as well.
Yes.
So we've really had a very broad range of experience.
And, well, it's been a couple of decades since you became a cost lawyer yourself, much like myself. Of course, we've seen some very interesting matters over the years. One of the areas that you particularly get involved with at Blackstone relates to quantification of costs and providing expert evidence in relation to class actions. Tell us some of your experiences in that space.
Sure, we've been involved with quite a number of class actions over the years, and that's really an area that's grown significantly in recent years, and with the number of class actions really grown almost exponentially, and I suppose the range and extent of those actions increasing. Our role as experts becomes pivotal.
Indeed, and in fact, some recent changes in the Queensland landscape for class actions seems to indicate there's a very rapid growth in that market, and some very large litigation funders are seeing Australia as a bit of a target now in terms of where they expand their own services.
Sure. One of the other areas I was going to mention is cost budgeting. So you'll be aware that in the UK there's been a trend to, I suppose, encourage law firms to advise their clients of the future costs. What we've seen in Victoria is a number of Supreme Court judges order at the directions hearing stage that parties provide a detailed cost budget to the court. So it's basically filed as a statement of the costs which are likely to be incurred from that point onwards. And that encourages parties to consider the full extent of the costs that will be involved if they proceed to a hearing. And it's very encouraging that parties turn their minds to, I suppose, the substantial costs that can be incurred if they do proceed all the way to a final judgment.
Just being aware of the consequences of taking an action and perhaps losing, being aware of the expense that they're going to. And what sort of numbers are we talking about? Sort of surely not as little as, say, a $20,000-$30,000 litigation, but as I suppose experts who practice in this area, sometimes it's quite sobering to consider the numbers that are involved when you look at a matter that may run for 10 or 15 days with senior and junior counsel, expert evidence, and potentially the cost of both sides that the unsuccessful party may end up bearing. Those costs can often run into the hundreds of thousands. Yes, it is an interesting development, and perhaps arising from the Jackson reforms in the UK, and we have some very close colleagues we work with in the UK market in legal costs, and sort of almost foreseeing this trend, but it really is coming to bear fruit now in terms of really the developments in this space. I know that there have been a number of matters in the Supreme Court in the Ballarat registry that I've been involved with, in which we provided expert evidence relating to projected costs, and we're going to see more and more of this, I think. And Paul, tell me a little bit about some of your experience in relation to gross sum applications and some of the evidence you've been able to provide on that basis.
We've provided expert reports in relation to a number of gross sum applications. In fact, we worked in respect of the longest running county court decision, which ran before His Honour Justice Bowman a number of years ago. In that case, the parties consented to the costs being dealt with on a gross sum basis. And we found that process worked very successfully, and had the matter proceeded by way of a bill in taxable form and the usual taxation process, which can be sort of fairly clunky when you're dealing with very substantial costs.
Indeed.
We found, based on the expert evidence, the process was much more effectively dealt with.
Yes.
And ultimately, the Cost Court, which is a specialist jurisdiction that deals with cost in Victoria, was able to address those issues at an expert level very effectively.
Well, it's been great to catch up with you, Paul, and hear about some of the most recent developments in legal costs, and look forward to another chat soon.
Indeed. Cheers.